Imagine waking up tomorrow and the internet is just gone. Not for an hour, but for months. No WhatsApp, no news, no online banking, no school. In today's world, the internet isn't just a luxury. It's a necessity for education, business, and even medical services. But what happens when the state decides to pull the plug? In 2019, the region of Jammu and Kashmir faced the longest internet shutdown in our democracy. This led to a legal battle that changed how India views digital rights forever. Today, we are diving into Anuradha Bhasin versus Union of India, the case that put the government's power to switch off the internet on trial. To understand this case, we have to look back at August 2019. The government issued an advisory for tourists to leave Jammu and Kashmir and close the educational institution. Shortly after, Article 370, which gave the state its special status, was revoked.
उस दिन से अनुच्छेद 370 के सभी खंड लागू नहीं होंगे.
To prevent social unrest and spread of misinformation, the government didn't just restrict movement, they imposed a blanket ban on internet services. Section 144 of the CRPC was invoked to prohibit public gatherings, and for months, the region was in a digital blackout. This is where our petitioners enter. Anuradha Bhasin, a journalist who couldn't publish her newspaper, the Kashmir Times, and Ghulam Nabi Azad, a member of parliament, who couldn't communicate with his constituency. They argued that this wasn't just a restriction, it was a violation of their fundamental rights. In court, the arguments were a classic tug of war. The petitioners argued that the internet is a modern day necessity. They claimed that the shutdown violated Article 19(1)A, that is freedom of speech, and Article 19(1)G, that is freedom of trade and profession. They also pointed out a massive procedural flaw. The government hadn't even published the orders for the shutdown, making it impossible for the citizens to challenge them. On the other side, the respondents, that's the government, defended their actions as a preventive measure. They cited a history of cross-border terrorism and internal militancy. They argued that the internet is a tool for spreading fake news and inciting violence. According to Solicitor General, war on terrorism sometimes requires nipping the problem in the bud by restricting digital communications. Now, the Supreme Court had to answer some heavy questions. Number one, is using the internet a fundamental right? Number two, can the government keep shutdown orders secret? And number three, was a total ban proportional to the threat present over there? The court made it clear, the government cannot claim privilege to hide these orders. If you are going to restrict someone's right, you must tell them why so they can challenge it in the court. Regarding the internet itself, the court held that while access to internet wasn't explicitly declared a fundamental right in this case, the freedom to express yourself and carry on business over the internet is protected under the Constitution. And last but not the least, the most important part of the judgment was the test of proportionality. The court ruled that the government can't use a sledgehammer to swat a fly. Any restriction must, number one, serve a legitimate goal, number two, be the least restrictive option available, and number three, not be indefinite. The internet cannot be suspended forever. The court warned that a complete blockade every time there is a threat would lead to arbitrary power, and they ordered the government to review all existing suspension orders and only keep those that were absolutely necessary. So what changed? The court directed the government to publish all orders and mandated a periodic review every 7 days. While the internet wasn't restored immediately, full 4G services only returned to Jammu and Kashmir in February 2021, but the case set a global precedent for digital rights. However, the struggle continues. Even after the judgment, groups like the Foundation of Media Professionals found that many states still didn't publish shutdown orders. The Anuradha Bhasin case reminds us that in the digital age, the off switch for the internet is also an off switch for the democracy. Freedom of press and freedom of speech are not just words on paper, they are the lifeblood of our society, and they must be protected even and especially during times of crisis. As the technology evolves, The law must evolve with it to ensure that security of the state never becomes a permanent excuse to silence the voices of the people. Don't forget to like, subscribe, and hit the bell icon for more deep dives into the laws that shape our world. Thank you.